The Stark Law governs the financial relationships between physicians and entities that file claims for certain designated health services. It also defines exceptions for financial relationships that HHS has determined do not pose a risk for program abuse. The new changes reflect a movement toward more value-based care and better care coordination. So the intention is to improve the entire patient care experience and make it easier on providers. The changes reduce administrative burdens and compliance burdens, and they maintain safeguards to protect patients from fraud and abuse. There are essentially 3 new exceptions and definitions for value-based compensation arrangements between or among physicians, providers, and suppliers. The exceptions include value-based arrangements with A, full financial risk from a payer for patient care services for a target population, B, value-based arrangements with meaningful downside financial risk for failure to achieve the value-based purposes of the value-based enterprise, and C, any value-based arrangement that meets those requirements. A value-based enterprise is any group of clinicians, providers, or suppliers that have agreed to collaborate and put the patient at the center of their work through greater care coordination, increased efficiencies in the delivery of care, and improvement in patient outcomes. Also, another aspect of the changes is that any money paid for a service cannot exceed the fair market value or influence a reduction in medically necessary patient services. Additionally, a patient's express preference for a provider supersedes a physician referral, so the referral cannot counteract the patient's preference. There are also 8 new safe harbor provisions put forth by CMS for certain coordinated care and value-based arrangements. These include safe harbor exceptions for 1. Patient engagement tools, CMS-sponsored arrangements, cybersecurity and technology, electronic health records, personal services, management contracts and outcome-based payments, warranties, local transportation, and ACOs. These changes are meant to push your practice away from fee-for-service arrangements toward value-based care arrangements. So it's based more on quality of care versus volume of services. With these exceptions, certain arrangements that were not legal before will now become legal. For example, a practice can now lease employees from hospitals, like nurses. Hospitals can also provide practices IT infrastructure to help with coordination of care between the practice and the hospital. And practices will also now have the ability to enter into gain sharing arrangements, so it's great. Well, I highly recommend that practices speak to their healthcare attorneys or a compliance expert to make sure that their arrangements are compliant and determine what they need to do to make the most of these changes. Fortunately, the compliance barrier has been lowered, and there may be more opportunity to enter into new arrangements that will benefit your patients and your practices. These changes have the potential to reduce your costs and improve quality of care. Prior to these changes, as you know, the Stark Law really paralyzed a lot of my clients because it posed such a strict liability.